Welcome to U.S. Immigration TV. Now, I'd like to thank all of you for your continued support and for subscribing to my YouTube channel. Now, I can't believe it's been over a year since we started U.S. Immigration TV. And I've been an immigration lawyer for decades. But you know, it's only because of COVID that I would never have imagined I'd be on a YouTube channel. But you know what? It gives me more opportunities to share with you what I'm most passionate about: immigration law and helping people legalize their status and live the American dream with their families under one roof. Now, I really am thrilled and humbled, that so many of you have posted your comments and questions. And I truly thank you from the bottom of my heart for all of your positive comments you've been sending my way, as well as your questions. So in this episode, I'd like to answer some of the questions you've posted. So watch this video until the end to see if your question may have been answered. And if you find the information helpful, make sure, of course, to like, share, and most importantly, subscribe. And also let me know in the comment sections at the end of the video if you found this format, this type of video helpful to you, where I answer viewer questions. All right, the first question comes from Hill Paradise. Good evening, attorney. I have a deportation order last 2008, but I did not leave the U.S. Now I got married to a U.S. citizen in 2017, and my wife filed a petition for me, and it was approved last November 2019. Now, my question is there any possibility to file for a change of status, or I guess he means adjustment of status, without hearing by the deportation order? All right, here's the answer. But what I would recommend before I give you the answer is you should see an attorney, because when you have deportation orders, I don't think it's something you should be handling yourself. All right, the first thing I would want to know is, why were you deported? What was the charges against you? If it was a felony or drugs or something like that, that could be very serious. If it was overstay, that's something that may not be as serious. The issue is that deportation order is still out there. And so therefore, you would have to get the deportation proceedings reopened and terminated or adjusted in front of an immigration judge. Because if you file the adjustment of status while that deportation order is still out there, the immigration officers don't have jurisdiction over the case. So bottom line, the answer is you probably have to get the deportation or removal case reopened and terminated so that you can adjust based on your wife's approved petition. Next question comes from June. Hi, Attorney Gurfinkel. I watch your video. Thanks for the information about immigration. I've been here for almost 20 years and am out of status working as a caregiver. I pay my taxes every year. My question is, am I qualified for the amnesty if there is one? Am I considered an essential worker? All right, first of all, although Biden had proposed an amnesty, it's still stalled in Congress. So there's nothing to apply for right now. We all just have to keep waiting, hoping, and praying it moves forward in Congress. So when people are saying, am I eligible for the amnesty? There is no amnesty yet. Another thing you may want to explore is if you are out of status, you may not be eligible to apply for the green card or just status in the U.S. unless you have the benefit of 245I or the Life Act. If you have a spouse or parent who's a citizen or immigrant, you can have an employer petition you as a caregiver, and you can apply for your visa outside the U.S. at the U.S. Embassy through provisional waiver. Again, I would recommend that you consult with an attorney who can fully evaluate your case and see if there could be options right now. In fact, I did a video, things that you can do now while waiting for an amnesty, and I invite you to go watch that video because maybe there can be some tips or insight for you. Next question comes from Begalita. Good day, attorney. Can a green card holder daughter petition her undocumented parents? Hope you get the chance to answer this question. Thank you and God bless. And yes, I do have the chance to answer your question. The answer is no. Green card holders or immigrants cannot petition parents. Only U.S. citizens can. So my recommendation is that first become a U.S. citizen. Also, if you were consulting with me privately, and obviously I do have many people who consult with me on a one-to-one basis, I'd like to look more into your parents' immigration history. Do they have fraud? Did they enter the U.S. under a different name? Did they cross the border? All of those things could have an effect on a person's eligibility to apply for a green card in the U.S. For example, even a petition by a U.S. citizen, if they cross the border without inspection, they may not be eligible, or entered as a crewman or Fiancé and didn't marry the U.S. citizen who petitioned them. Next question comes from Riza. Sir, my son's petition papers are already current and I've submitted the affidavit of support and paid the DS-260. That's the immigrant visa application. But I became a U.S. citizen. What will happen to my son's petition? Why did the NVC say that he's ineligible now? Please help me, Attorney Gurfinkel. Well, the first thing I would like to know on that is, why did the NVC say your son's no longer eligible? I mean, it could be that he was processing the case and then the immigration ban happened and then they were canceling a lot of cases, but now the ban is over and the embassies are starting to reopen. In fact, I did put out a YouTube video on that subject about how the embassies are opening and prioritizing the various different kinds of cases. So I need to determine why they said your son was not eligible. If you petitioned him as an adult, what's called F2B, adult single child of immigrant, and then you naturalized, that should not have had an effect on his case. So again, I would recommend you probably see an attorney who can fully evaluate the facts of your case and also recommend a course of action so that your son hopefully can get his visa. Next question comes from Alex. Can a U.S. citizen stepfather petition an over 21 years of age stepchild to migrate here to the U.S.? All right, here are the basic rules about step-parent petitions. The bottom line is, in order to create a step relationship, the person has to marry the biological parent before that child's 18th birthday. So I'd like to know whether or not you married the child's parent before the child's 18th birthday. Then you could have a step relationship. And that goes either way. Either the step-parent is a U.S. citizen and then can petition the stepchild, or if the stepchild's a U.S. citizen and the step-parent is, let's say, out of status, but they get married before the child's 18th birthday, the stepchild can petition that parent or step-parent. Now, I hope you found my answers helpful and informative, and I hope that they provide some information either to you or maybe somebody you know. And if you like this video, please leave your comments in the comment section and let me know your questions or future topics that you would like me to cover. So stay tuned and I'll try to get to your questions and comments maybe on another video. In the meantime, I hope you continue to like, share, and subscribe, and comment and inform your family and friends about this channel. Make them subscribe as well, so we can continue to keep you posted on the latest immigration developments and hopefully answer some of your immigration questions. I'm Michael Gurfinkel, and this is U.S. Immigration TV, and thank you for watching.